Snow is here. This was scheduled for final pre-trial for assault and battery. Is the complaining witness here?
Complaining witness not here. We've attempted to reach out to complaining witness. I had contacted him once, but since then he hasn't returned my call. The state cannot sufficiently move forward without the complaining witness, so this time we move to dismiss this case.
Motion to dismiss is granted without prejudice. The people do have the right to reissue it against you. You understand that? Yes. We'll get you a copy of dismissal in just a moment. State of Michigan versus Jason Sauer, 25-00533. Appearance, please.
Thank you, Your Honor. May it please the court, Prosecutor Attorney Dan Smith, here on behalf of the people.
Under Justice Ross, on behalf of Mr. Jason Sauer, who is standing to my right.
Sauer had a jury trial today for malicious destruction of property. We are running another matter today, so we can't proceed. Is there a resolution now at this time?
Yes, Your Honor.
What is the resolution?
The offer is to amend count 1 to malicious destruction of property under 200. And there is, we're not asking for restitution.
That's correct, counsel.
Yes, Your Honor.
You want to accept that, sir?
Yes.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Counsel, you want to put the truth and the license, right? Okay, and then Mr. Sauer, you understand your right to the presumption of innocence?
Yes,
You have the right to maintain your innocence and proceed to a jury trial and require the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt. You understand that? You have the right to remain silent at any trial that can't be used to prove or imply that you're guilty. You have the right to question any witness that is called to testify against you, and the right to subpoena witnesses to testify on your behalf. You understand those rights?
that's it.
You're willing to give those up today to plead guilty to the amended charge? Anyone threatening you to do that?
No,
Any promises being extended to you to get you to plead guilty to the malicious destruction of property less than 200?
no,
Are you currently on probation or on parole?
I'm on probation, Clayton County.
Until when?
I think it's another year. Yeah. So I got like 2 years.
For another year?
Yeah. But I've been doing, I was in TRICAT for 5 months, so it all adds, and I was in jail 10 months before that.
You understand that by pleading guilty to result in a conviction, that you may need to report for your probation status.
Okay.
You understand that?
Yes, I do.
It also could be a conviction that may have impact on travel or immigration status. You understand that?
Yes, I do.
It also may need to be reported on a job application or be reported to your current employer. You understand that?
Yes, I do.
Lastly, are you looking to plead guilty because you believe that you are guilty?
Yes, I do.
As to malicious destruction of property less than 200, how do you plead?
Guilty.
Factual basis.
Mr. Sauer. On January 12th of 2025, were you located at Northeast Street in Lansing, Michigan, 48906?
Yes, I was.
And at that location, is there a place of business called House of Faith?
Yes, I was.
Okay, and this place is located in Eaton County. And at that location, did you maliciously destroy or injure a mailbox?
Yes,
And was that mailbox located on a front grassy area in front of House of Faith?
that's correct.
I do think that satisfies me.
People satisfied.
If we're satisfied with the factual basis, I'll accept your plea or find your plea to be voluntarily and intelligently made. He's on probation until when?
I think he said for another year.
Sentencing date is July 7th at 9 a.m.
Would your honor entertain a motion for immediate sentencing?
I will not.
Okay. Like to appreciate that.
Yes. Or give an update as to his probation status and requirements from Clinton County, so that we can see what needs to be done, if anything, on this end. All right, so your report and check in with our probation department before you leave here today, okay? Any additional matters for the record?
Nothing on the paper, Your Honor.
Okay, thank you. Your Honor.
Thank you. State of Michigan versus Rhonda Wade, 25-03773. Appearance, please.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
This is a public defender Justice Straub on behalf of Ms. Rhonda Wade, who is standing to my right.
Ms. Wade was scheduled today for jury trial. Do we have witness here?
Yes, we are. We are prepared.
Is there a resolution?
No time, no.
Okay, so this is continuing to trial?
Yes.
Okay. This has to be reset because we're running another trial. May 26 at 8 for this one. May 26 at 8. It's probably the priority. Yeah, this is the priority because it's a 25 case. Any additional matters for the record?
Nothing on the paper, Your Honor.
Nothing further, thank you.
You're all set, thank you.
I'm on behalf of Ms. Tricia Hendricks, who is standing to my right.
So we have two motions. The jury is here. Two motions the court needs to make a ruling on. I believe there's one about expert testimony, and that the people are looking to call a veterinarian and then have them qualified as an expert. I think that there was sufficient notice provided to your office because that there was notice in the original, in the April iteration of jury instructions, that that person was identified or intended to be identified as a possible expert witness. Whether or not they'll be qualified as experts, totally different. The other concern as it relates to this is you would know better than the court would regarding the nature of the allegations. And just based off the affidavit of probable cause, the allegations were that I believe there was an animal left in the cold on the porch or something to that effect in the kennel. And so the allegation is that that would cause some harm or cruelty to the animal. I don't think it's unreasonable to think that a vet would be called for an animal cruelty. Typically, animal cases is going to have animal control and the vet. It's typical. So I don't think that's particularly an ambush issue. So I will grant their motion to allow them to call that witness and deny your motion to exclude that as a potential expert witness. We'll deal with qualification once the foundation is properly laid. So if you need to re-raise an objection, that you can do so at that time. As it relates to the motion for district court to use Zoom to take testimony of the witness. My understanding that this is a witness that allegedly contacted animal control.
Yes. Yes,
And
sir.
why, again, is this witness not in the United States?
Due to his immigration status.
What do you mean due to his immigration status? He just got picked up, or did he have a warrant to which he got picked up? A criminal matter.
From my understanding, Your Honor, and I know he has a Fifth Amendment privilege, but from what I gathered, when he may have been here illegally, when Trump came into office, he self-deported.
Okay, so it wasn't that he got a criminal conviction or picked up on a criminal matter and that's why he was deported, because that would change my position. then I do deem him as being unavailable. Under the court rule exception, I will grant him the permission to appear via virtual access to give testimony because of the ongoing issue. I don't see how he could be available and be in this country at this point without a proper immigration status. Any additional motions that I did not rule on?
There's a particular matter, Your Honor, that I would like to address. I would like the court to take judicial notice of a couple facts. I believe there's sufficient basis for my reading.
Why am I saying judicial notice? Because this is a jury trial. So what am I gonna do with it?
A couple facts that I would like to use in my opening statement.
Okay.
Regarding the care for this particular animal. The American Kennel Club has indicated that the pet in this particular case should be exercised several times a day, and that in the winter it should be exercised in the house. The American Kennel Club also states that this clean, fresh water should be available to this dog at all times.
This particular dog
This particular
versus any other.
this particular breed of
This
dog.
is like a specialized breed of animal, is what you're saying?
I'm reading it right off.
Your witness, your expert can't testify to that?
I'm not sure if they can or not.
Okay.
But this
But
is,
this is something that you want to state in your opening.
yes, that's it. That
Okay.
the premier organization that handles dogs, but they've made a conclusion that
Okay.
these two things are a fact about this particular breed of dog.
Counsel.
Your Honor, it is my understanding that judicial notice is appropriate where facts are obvious, or where something is so evident, right, that there is no debating it. I would absolutely say that this is a matter for debate. It is up for us to determine today whether or not this material, I have not reviewed it. I really don't know what it says.
I don't either. I'm not familiar, and I don't know that I can take judicial notice of whatever. What is it, the American dog?
The American Kennel Club, they're the one that holds the special like dog show every year.
Listen, I can't help you with that. I don't know anything about it. I don't have any pets. So I don't know who holds the special, any of those things. I don't know anything. I don't even know what this particular breed would look like. And so I would imagine if this was a specialized issue, those are the reasons why we have expert witnesses, and so that they can testify if there was a special condition upon which this particular dog needed to be kept. I can't take judicial notice of that. That's not something that's common. Or, you know, something that went through this court system, and that's why I'm taking judicial notice. So for that reason, no, I cannot take judicial notice of that you're gonna have to lay foundation to get that information in.
Okay.
Through one of your witnesses. Any other, you said you had a couple of
No,
issues?
no.
Okay, they were all relevant to that. Okay. And then you're also gonna lay foundation as it relates to the picture.
So, yes, so you deny my
Okay.
motion to introduce this during the opening statement.
Okay. And so any other matters for you?
Yes, Your Honor. So I do believe that the last time we came before this court in this case, that it was clarified that the license count had been dismissed. I don't think that it should be on the verdict form today.
The issue.
Yes, we took this matter up with Hannah Buckingham.
Yeah, Nolly, no license was on February. That's correct.
And then lastly, from defense, we would just simply ask this court to sequester all the witnesses.
Sequestration is granted. Any other matters?
That's from the people.
Not from defense.
Let me see. And did you receive the jury instructions? I would need to delete the no license jury instruction. Actually. Any other changes that need to be made?
I haven't had an opportunity, Your Honor, to take a look at them.
Okay, if you can do so at the same, I'm going to obviously handle that matter for Mr. Sturdivant's clients. And then. And then we'll call this case again.
Thank you.
Verdict. The verdict form, proposed verdict sheet. You can let us know if you want changes.
Oh, yeah.
Your Honor, may I approach?
Thank you. That's what it needs to take it up from there. Back on the record, or on the record, that is in the state of Michigan. Versus Cameron Johnson, 25-00164 appearance.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith. Your Honor.
Morning, Your Honor. Daniel started appearing for Mr. Johnson, who is here in the courtroom standing to my right.
Sorry. 25-00164. Oh, so what's this for? Only regular I have here. Today was the date that was scheduled for a, was this final pretrial? No, this one was just a pretrial.
Correct.
Okay. And then my understanding is that the defendant is going to plead to an amended count of attempted animal cruelty. Is that correct?
Yes, with agreement for no further upfront jail at time of plea and Homes Equal Training Act status.
You want to accept that offer, sir?
Yes.
Raise your right hand. Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
Okay, this is an advice and rights and plea information sheet. Is that your signature?
Yes.
You can put your hand down, sir. You understand that you have the right in this matter to proceed to a jury trial?
Yes.
You are presumed innocent until proven guilty. Do you understand that? You have the right to require the prosecutor prove your guilt by proving each element beyond a reasonable doubt. The right to question any witness that's called to testify against you, the right to subpoena witnesses that will testify on your behalf. You understand that? Are you willing to give up those rights to plead guilty to the amended charge?
Yes.
Anyone promising you anything not stated on the record to get you to do that?
No.
Have you been threatened in any way to get you to plead guilty to the amended charge?
No.
Are you currently on probation or on parole? You understand that a guilty plea could result in the conviction that you may need to report to a current or future employer.
Yes.
It also could have impact on where you can travel or get immigration status. You understand that? Okay. As to the amended charge of animal cruelty to one animal, amended to attempted animal cruelty to one animal, how do you plead? Factual basis, please.
Thank you. Mr. Johnson, back in May through July 2024, were you in ownership of a dog in Lincoln County?
Yes.
And at that time, did you fail to ensure that it had adequate food, water, and care in that time frame?
Yes.
It was your responsibility as owner of the dog to ensure that, correct?
Yes.
Thank you.
People were satisfied.
The court is also satisfied with the factual basis on the plea and finding your plea to be freely, voluntarily, and intelligently made. Sentencing is going to be June 30th. And we'll get a status from probation as to his eligibility for HIDA. Any additional matters for today's?
Nothing
work?
from the people, Your Honor.
I'm sorry, Your Honor, what time on the 30th?
9 a.m.
Thank you.
You, any additional matters?
No, Your Honor.
Nothing from the people, Your Honor.
Thank you, you're all set.
I actually have Mr. Johnson. He is wondering whether or not the court would consider amending his bond to allow for release. He would potentially, if the court is amenable with tether.
People opposed to amendment of bond, Your Honor. Opinion has gone since 2024.
You're not telling me. I see how many purple failure to appears and remands. I've been trying to track this boy down for 2 years. Now we have several bond violations on top of 1, 2, 3, 4 files for him.
Thank you.
I will continue as is. You're all set.